Special counsel Jack Smith is letting nothing slide in his criminal case against the former president for his efforts to overturn the 2020 election. On Friday night, prosecutors asked federal judge Tanya Chutkan, who is overseeing the case, to impose a so-called protective order preventing Trump from publicly releasing evidence that would be handed over to his lawyers in the discovery process, citing recent threats made by Donald Trump and what has become a years-long practice of threatening anyone who tries to hold him accountable. Now, in their motion for a protective order, the Justice Department says, quote, such a restriction is particularly important in this case because the defendant has previously issued public statements on social media regarding witnesses, judges, attorneys, and other associates and legal matters pending against him. And in recent days regarding this case, the defendant has issued multiple posts, either specifically or by implication, including the following, which the defendant posted just hours ago. If you go after me, I'm coming after you. The filing including a screenshot of that ominous threat. Prosecutors went on to say that, quote, if the defendant were to begin issuing public posts using details or, for example, grand jury transcripts obtained in discovery here, it could have a harmful, chilling effect on witnesses or adversely affect the fair administration of justice in this case. Now, that request by the special counsel triggered a battle between Team Trump and the DOJ. Here's how the New York Times describes that. First, John F. Lauro, one of Mr. Trump's lawyers, filed court papers to Judge Chutkan asking her to push back the deadline to object to the protective order until Thursday. Mr. Smith's team shot back, telling Judge Chutkan that the government needed the order in place to start handing over discovery evidence and accusing Mr. Lauro of seeking to delay the process. The government stands ready to press send on a discovery production, Thomas P. Wyndham, one of the prosecutors, wrote. The defendant is standing in the way. Now, the Justice Department seemingly called out Team Trump for a tactic that they are widely expected to use in any of the criminal cases facing the ex-president, delaying any and all proceedings so that a trial can't take place until after the 2024 election. The judge denied Trump's request for that delay, and their response to the proposed protective order is now due within the hour. All of this has been taking place as Trump's lawyer, John Lauro, has been making the rounds on television, giving a preview of what we can expect as Trump's defense. Take a listen to what he had to say in response to comments made by Mike Pence.
He said the president asked him to violate the Constitution. He said the president asked him to violate the Constitution, which is another way of saying he asked him to break the law.
He never said. No, that's wrong. That's wrong. A technical violation of the Constitution is not a violation of criminal law. That's just plain wrong. And to say that is contrary to decades of legal statutes.
Let's get.
All right, so here's what January 6th Select Committee member Jamie Raskin had to say specifically about that.
A technical violation of the Constitution is a violation of the Constitution. The Constitution in 6 different places opposes insurrection and makes that a grievous constitutional offense. So our Constitution is designed to stop people from trying to overthrow elections and trying to overthrow the government. But in any event, there's a whole apparatus of criminal law which is in place to enforce this constitutional principle. That's what Donald Trump is charged with violating. He conspired to defraud the American people out of our right to an honest election by substituting the real legal process we have under federal and state law with counterfeit electors. I mean, there are people who are in jail for several years for counterfeiting one vote. If they try to vote illegally once, he tried to steal the entire election. And his lawyers up there saying, oh, that's just a matter of him expressing his First Amendment rights. That's deranged. That is a deranged argument.
Joining our conversation, former top Justice Department official and MSNBC legal analyst Andrew Weissmann is here. Also with us, former Assistant Director for Counterintelligence at the FBI, Frank Figliuzzi, and from the Washington Post Congressional Investigations reporter, Jackie Alamany. It's great to have all three of you with us. So, Andrew, I'll start with you. I am no lawyer. I'm not going to pretend to be a lawyer, but let's just take Lauro's comments here for 1 second. Asking someone to violate the Constitution sounds to me like you're asking them to break the law.
Well, that certainly is absolutely true. It is a separate issue whether they're violating a criminal law. And so, yes, if you ask somebody to violate the Constitution, that is something that is a violation of law by definition, because the Constitution is one of our laws. Whether it violates a criminal law depends on the criminal statutes involved. And here, this isn't some technical violation. This isn't some arcane provision in the Constitution. This is, as Jamie Raskin very eloquently and clearly explained, something that's fundamental. And there is a whole series of criminal laws that have been violated according to the indictment, which means that there has been probable cause found by the grand jurors that this is what the former president did. Obviously, it remains to be seen whether it can be proven beyond a reasonable doubt. But the sort of back and forth with John Lauro is, let's just call it out for what it is. It's not a serious argument. This is sort of repartee. It may play to the base, which is, I think, what it's all about, which is the court of public opinion. And by the way, this is a lot of what defense lawyers need to do. I mean, this is part of their job, is dealing with sort of the court of public opinion. But in terms of a serious legal argument, that is, I would be really surprised if that ever saw the light of day before Judge Chutkan, because it's just not a serious argument.
Let me play a little bit more of what Lauro had to say yesterday, Jack, and I'll get your thoughts on it. Listen.
At what point does he accept the truth that he didn't win?
Well, he believes he won, and the Biden administration will never be able to prove beyond a reasonable doubt that he didn't. But what he's being indicted for ultimately is following legal advice from an esteemed scholar, John Eastman, that he could petition his own vice president and ask his vice president to pause the voting on January 6th to give the states one last chance to certify or re-audit. That was the ultimate ask that President Trump made in his ellipse speech. That's clearly protected.
Jackie, I mean, you can see the contours of the legal defense forming here, with perhaps it resting on this idea that Trump believed he had the right to say what he had the right to say, something that even Jack Smith agrees with. But give us the overall view of what the defense strategy appears to be from Lauro making the rounds over the weekend on multiple outlets.
Yeah, Eamon, I think you just laid it out in simplest terms, which is that the president at the time when he was president believed that he had won the election and continues to believe that. And it's actually going to be a central tenet of his claims and his platform going into 2024, furthering this argument of his false and unsubstantiated claims of a stolen 2020 election. And as we have previously reported at the Post, a key part of the case that Jack Smith is going to need to make is intent. That's why you saw in the indictment so many example after example of Trump conceding to some of his top allies and the people around him that the claims of election fraud were, quote unquote, crazy, or that he, conceded that he had lost, telling Mike Pence at the time that Pence was simply, quote, too honest. That's why you see Smith making this argument. It's why you saw that argument being made in previous opinions that were released even before the Justice Department was looking into this. That at this point now very well-known opinion by Judge Carter in California that had said that Trump and John Eastman were most likely guilty of trying to defraud the American people because they had both conceded at various times in correspondence and communications with other people that they realized that to some extent the legal argument they were making was not as on firm grounding as I think they would now like to be arguing.
Andrew, just to button up this part of the conversation, I mean, even Bill Barr isn't buying the advice of the counsel strategy that this was all John Eastman's idea. I mean, he said last week that it was Trump who went looking for lawyers who would basically tell him what he wanted to hear. first of all, give us your assessment of that argument. Is that a sound argument to be able to say, well, these were his inner circle advisors telling him he had the ability to pressure Mike Pence, he had the ability to reach out to fake electors if he believed that he had actually won that election? And why do you think John Lauro is doubling down on this strategy?
I think with respect to
as Andrew said, this plays exactly.
Sorry, Frank, I was just going to get Andrew's thought, but I'm going to come to you next. Apologies, Frank. Hold on 1 second. Andrew, go ahead, Andrew. Apologies, Frank. Go ahead.
Sorry, Frank. So with respect to advice of counsel, I think that one thing that I try to do is separate out the different nature of the schemes charged in the indictment. There are schemes for which there is zero legal advice at all. Nobody said that you can use fake electors and defraud electors and then use that to change votes. Nobody said it was lawful to threaten the Georgia Secretary of State with criminal prosecution to try and get him to change the underlying vote tally in Georgia. Now, there's a whole series of things that are charged for which there was no lawyer saying anything close to advice of counsel. With respect to the power of the vice president, which is one of the episodes, but just one of the episodes, there is a lawyer who Donald Trump sought out. But in order to have advice of counsel, you have to show good faith reliance on counsel. And that's where I think it's going to be very hard for Donald Trump to show that as a factual matter. I don't think he will testify. I don't think John Eastman will testify, in which case it's done. It's over. There's no proof that will be before the jury. But even if you were to have one or both of them testify, there is, as you say, this problem of literally keeping Pat Cipollone out of the room. That is not how you behave if you're trying to get to a good faith answer as to what the law is. You would have all of the relevant people in the room. I mean, let's just think about how George Bush or Barack Obama would have handled this situation where lawyers disagreed. You wouldn't go shopping and exclude the people whose advice, including your own White House counsel, were giving you. So there's just a lot of factual problems with even the sliver of the allegations for which there is some reason to think there was legal advice, that it would not constitute advice of counsel.